Welcome back to the 31st meeting of the Health, Social Care and Sport Committee in 2025, and we will resume agenda item 2, which is the continuation of day 3 of stage 2 proceedings on the assisted dying for terminally ill adults Scotland Bill. And I call Amendment 188 in the name of Stephen Kerr, already debated with Amendment 173. Douglas Ross to move or not move?
Moved.
And the question is that Amendment 188 be agreed. Are we all agreed? Committee is not agreed. And we will go to the vote. Those in favour of Amendment 188. Those against? Abstentions? The result of the vote on Amendment 188 is 3-4-5 against. There were no abstentions and the amendment is not agreed. The question is that Schedule 4 be agreed. Are we all agreed? I call Amendment 36 in the name of Liam MacArthur, grouped with Amendments 246, 37, 38 and 247. I point out that if Amendment 246 is agreed to, I cannot call Amendment 37. Liam MacArthur to move Amendment 36 and to speak to all amendments in the group.
Thanks, Convener. I'll start again by addressing my own amendments before turning to the others in the group. Amendments 37 and 38 alter the death certificate requirements in Section 17 to also require the death certificate to record secondary to the primary cause of death as covered by Section 17(2) that an approved substance was self-administered under the provisions of the Act. Amendment 36 is a draft inconsequential. The Bill requires that the death certificate for a terminally ill adult that has had an assisted death under the provisions set out in the Bill must record the terminal illness as the primary cause of death. Explanatory notes add that it is expected that the substance used by the person would also be recorded on the death certificate as a secondary or additional cause. My policy has always been that both the terminal illness and the substance used should be recorded on the death certificate. I note the committee Stage 1 report concluded that both the illness, disease and condition which led to an individual requesting assistance to end their life and the approved substance provided to enable them to do so should be detailed on the death certificate, and my amendment would ensure that is the case. After further consideration as well as discussions with the Chief Medical Officer and others, I've lodged this amendment to ensure my policy is reflected on the face of the bill and that death certificates will capture both the underlying terminal illness as a cause of death, but also that an approved substance was used. This will ensure appropriate transparency. I note the Scottish Government's confirmation that this would require consultation with Public Health Scotland, National Records of Scotland and Health Improvement Scotland, as well as Health and Social Care Services, to ensure that deaths continue to be recorded in an accurate, consistent and helpful manner, and that new processes and investment would be needed to support this level of data collection, development and reporting, while also considering alignment with UK jurisdictions. I welcome that helpful clarification. I'm keen to work with the Government if in the case that there's further work required ahead of Stage 3. Turning to Pam Duncan-Glancy's amendments 246 and 247, these would change the death certification provision so that the approved substance used is listed as the primary cause of death and the terminal illness is to be recorded as an underlying condition. I certainly acknowledge the different perspectives on the issue, and while I remain of the view that the right and most transparent thing to do is to record the primary cause of death as the terminal illness, with the substance also being noted on the death certificate, I want to hear what Pam Duncan-Glancy has to say in speaking to her amendment, as well as other members on the committee, before deciding whether or not to press my amendment. But I move Amendment 36 for now.
Thank you, Mr MacArthur. Pam Duncan-Glancy to speak to Amendment 246 and other amendments in the group.
Thank you, Convener, and good evening. Amendments 246 and 247 would ensure a transparent and accurate recording of deaths resulting from assisted dying. Amendment 246 requires that the individual's terminal illness is listed as an underlying condition, while Amendment 247 requires that the act of assisted dying, including ingestion or administration of the approved substance, is recorded as the direct cause of death. These amendments promote what I think are honest documentation, supporting future public health monitoring and avoiding misleading records. The bill as it stands instructs that the cause of death for someone who undergoes assisted dying be recorded simply as their terminal illness. I think that's problematic, not least because of the fact that without a proximity to death test, it is difficult to say whether or not the terminal illness has been the direct cause of death at the time. Yes.
I'm very grateful for Pam Duncan-Glassie for taking intervention. My concern here, and I don't know, maybe you could address this, would be that it kind of skews things like, if it happens to be a cancer diagnosis, or it happens to be, not being recorded as that. I think that kind of skews a lot of the data potentially in the health sector. I don't know how you would maybe address that.
I thank the member for the intervention, and I understand that it could do that. I suppose in one sense you could say that you would see data on deaths from both change in effect. But I think the problem that we've got is that ultimately not including the assisted death element of the death on the certificate means that we could be suggesting that cancer, for example, is the example that you used, was the cause, but we don't know yet whether it would be the cause because the person has instead died as a result of the ingestion of the substance which has caused the death at that time. And I think that we could run the risk of under-reporting the numbers of assisted deaths, but also we could run the risk of not reporting accurately the reason for the person who died. It could for why the person died. It could be that the person may not have died of their terminal illness. Something else indeed could have ended their life. And in this case, that something else would be the ingestion of the substance that they have chosen to take in order to end their life. I think including the terminal illness on the death certificate is important, and that's why it doesn't say that it wouldn't be there. It just says that we can't accurately say that it was the terminal illness that caused that death, because at that moment in time it wouldn't be necessarily. And I don't think recording something that isn't necessarily accurate in something as important as this is right nor proper. I appreciate that this is a difficult issue, but I think nonetheless accuracy is really, really important. So too is transparency. And if deaths are recorded in a way that doesn't highlight that it was as a result of the assisted death at that time, I think we would make it difficult in future. Not only would it not be accurate, but it would be difficult to evaluate the social, medical and ethical impacts of this legislation to an extent. Yes.
I thank Pam Duncan-Glancy for taking the intervention. Can we maybe roll this back a wee bit and think about what is the purpose of a death certificate? And a death certificate is there, not for statistics, but a death certificate is there so that grieving loved ones can bury or cremate the body of the person that they've lost. It gives them permission to be able to do that legally that process can happen. And I think here we're maybe getting a bit caught up in collecting data when actually at the end of the day there's a grieving family or grieving loved ones left behind who want to be able to carry out their loved ones' last wishes. Does Pam Duncan-Glancy perhaps accept that perhaps we're going down a little bit of a rabbit hole in what is actually on a death certificate as opposed to allowing a family to then carry out that process?
I thank the member for the intervention, and I take the point. But when I think back to the death, for example, of my own father, the detail that was on the death certificate, there were two different aspects to the death certificate, and I won't go into the detail, not because I don't necessarily want to, but in the interest of time. And both the information on the death certificate and the fact that we had a death certificate and could therefore move forward with all the processes that a death certificate allows to happen were quite important because it allowed us to understand the circumstances in which my father died. And had we not seen the detail in the death certificate, there was a primary and a secondary cause of death. Had we not seen the full detail of that, we wouldn't have understood the impact of some of the things and some of the changes in his life that had led indeed to his death. So I think it is about more than just a death certificate being there as a performative, something that, not performative, that's not the right word, perfunctory perhaps, piece of paper that allows you to then move on and with the cremation or burial or however you want to proceed. I do think it's an important part of the grieving process. And in this instance, I think that families will want to understand whether or not indeed it was the terminal illness or whether it was their loved one's choice to end their life that ultimately ended their life. And not accurately recording that, I think, could leave questions, many questions, over family members, hanging over family members for a significant amount of time. I'll just finish this tiny piece of point and then I'll bring you in. I think it could leave questions. How much longer could the person have had? Did they die of that or did they not die of that? And I actually think it would be really difficult. And so I think it's important for both matters of data collection, yes, but I think that is secondary, in fact, to the point the member made about the grieving process and the importance of families fully understanding what their loved one has gone through. I'm happy to take the intervention.
I thank Pam Duncan-Glancy for taking the intervention. And just to explore this a little bit further, have you had any conversations with the National Records for Scotland or Public Health Scotland in terms of their interpretation of data that's collected on a death certificate? And I am thinking about the point that Brian Whittle was making, just roundabout if we had a cluster of a certain type of cancers in an area and the information that would then pertain, would that follow through if it was in this, the secondary place or the primary place on the death certificate? I'm just wondering if you've had any interaction with them to kind of understand how that information is used. Thank you.
I thank the member for that intervention. And in that level of detail, I'll be honest, I haven't. However, what I do understand is that sort of information and detail is quite important for the accuracy of recording how many deaths to cancer, for example, there were, which could still be used as the primary or the secondary cause of death, could still be counted. And I don't think it would be beyond National Records of Scotland or indeed Public Health Scotland to be able to work within a system that was set up specifically to look at this particular issue. Was this the primary cause of death, or was it the underlying condition that was the primary cause of death? I think that there are systems, tried and tested systems that have been used for a long time that would be able to manage that question. The point I'm making, I suppose, just now is that I think Parliament has a responsibility to set the parameters for this legislation and to be really clear about what we want to record, but also how we want it recorded. And I think it's important, both for the sake of data collection, but also for the sake of closure and understanding from families, that we record accurately what the cause of death was. And if someone has a terminal illness, if someone has cancer, and forgive me for putting it like this, if someone has cancer and they die in a car accident, the cause of death is not the cancer. The cause of death is what happened that caused their death. And I think we have to be really careful about how we accurately record these things. And I appreciate that those are different examples, but I'm trying to illustrate why I think it's important that we accurately record what caused the death of that person at that time. And it doesn't take away from the fact that we also say that the person had a terminal condition. I'm sure it could still be recorded and should still be recorded. But ultimately, that isn't what caused them to die. And I think with that, I'll bring my remarks to a close. Thank you.
Thank you, Ms Duncan-Glancy. Liam MacArthur to wind up and press or withdraw Amendment 36.
Thanks, Convener. Can I thank Pam Duncan-Glancy very much indeed, both for lodging the amendments and walking us through the rationale for opening up the debate. I think we absolutely need to be having on this issue. I think I would reflect that the one change I made subsequent to the consultation of my proposals all those years ago was beefing up the requirements around data gathering, because it is crucial. I mean, to some it may feel a bit dry, a bit bureaucratic, but it's absolutely critical in understanding how the Act is operating, who's accessing it, in what circumstances, etc. But there are wider implications for data gathering. Brian Whittle, I think, spoke to that very pertinently as well. So I think I would make the point that those accessing eligible for this under the provisions of my bill would have an advanced progressive terminal illness. I think there'd be little doubt about the fact that the terminal illness is going to lead to their death. We've had the debate around the prognosis period, and I'm almost certain we'll come back to that at stage 3. But I wouldn't like the committee to... Certainly, Mr Whittle.
I'm really sorry to prolong this particular issue, but I'm struggling here because You know, and one of your amendments is recorded as the direct cause of death would be the terminal illness, but it isn't. Of course, it's it's why they are accessed. You know, the assisted dying is because of an illness that is ultimately going to lead to their death, but it's not the direct cause of death. And I'm really struggling with between your amendment and Pam Duncan Glancy's amendment here, and I don't know where I can go with this. To be honest, I think probably the answer lies between them both somehow.
You're not alone, Mr. Whittle. Can I say that? I think the point you make is again entirely pertinent. I think in the discussions I've had with the Chief Medical Officer, there was not necessarily a strong view that this has to be done in a particular way. What there is an absolute clarity of understanding that both aspects would need to be captured in the death certificate. My amendments propose one way of doing that, and Pam Duncan Glancy has helpfully given the opportunity for the committee to consider another alternative way of addressing this issue. I think at this stage, convener, rather than leave the issue unresolved from my perspective, I would press my amendment to a vote, but with the assurance that I'm happy to work with Pam Duncan Glancy and others ahead of stage 3 to see if there are further refinements to this that need to be made to address the points that Pam Whittle and others have made about this. This is difficult stuff, but I don't believe that it is insurmountable. But I think it's important that at stage 2, the bill is at least amended to address what I think is a shortcoming in the way that it's currently drafted, and on that basis I'll press Amendment 36.
Okay. The question is that Amendment 36 be agreed to. Are we all agreed? I call Amendment 246 in the name of Pam Duncan Glancy, already debated with Amendment 36. I remind members that if Amendment 246 is agreed to, I cannot call Amendment 37 due to preemption. Pam Duncan Glancy, to move or not move?
Move.
The question is that Amendment 246 be agreed to. Are we all agreed? Committee's not agreed, and we'll move to a vote. Those in favour of Amendment 246? Those against? Abstentions? The result of the vote on Amendment 246 is 1 for, 7 against, no abstentions, and the amendment is not agreed to. I call Amendment 37 in the name of Liam MacArthur, already debated with Amendment...
Apologies, Convener. Sorry, that was incorrect.
Okay, I'll give the results of that vote there again. So, Amendment 246, 1 for, 6 against, and 1 abstention. The amendment is therefore not agreed. Call Amendment 37 in the name of Liam MacArthur, already debated with Amendment 36. Liam MacArthur, to move or not move?
Move, Convener.
The question is that Amendment 37 be agreed to. Are we all agreed? No. Committee's not agreed, and we'll move to a vote. Those in favour of Amendment 37? Those against? Abstentions? The result of the vote on Amendment 37 is 7 for, 0 against, and there was 1 abstention. Therefore, the amendment is agreed. I call Amendment 38 in the name of Liam MacArthur, already debated with Amendment 36. Liam MacArthur, to move or not move?
Moved.
The question is that Amendment 38 be agreed. Are we all agreed? Committee's not agreed. We'll move to a vote. Those in favour? Those against? Abstentions? The result of the vote on Amendment 38 is 7 for, 0 against. There was 1 abstention and the amendment is agreed. Call Amendment 247 in the name of Pam Duncan-Glancy, already debated with Amendment 36. Pam Duncan-Glancy, to move or not move?
Move.
The question is that Amendment 247 be agreed to. Are we all agreed? Committee's not agreed. We'll move to a vote. Those in favour of Amendment 247? Those against? Abstentions? The result of the vote on Amendment 247 is 1 for, 6 against, and there was 1 abstention. Therefore, the amendment is not agreed to. The question is that Section 17 be agreed to. Are we all agreed? Thank you. I call Amendment 189 in the name of Murdo Fraser, grouped with Amendments 200 and 214. Murdo Fraser to move Amendment 189 and to speak to all the amendments in the group.
Thank you, Convener. I have one amendment in this group, Amendment 189. The purpose of 189 is to allow the next of kin or a relative to request an independent medical review if they believe the deceased did not meet the eligibility criteria in the bill. 2 independent doctors in that case, not involved in the original case, must examine all relevant records, and if they find evidence of a breach, refer the matter to the Procurator Fiscal. The number and outcome of such reviews must be included in the statutory review under Section 27 of the Bill. And the reason for this, Convener, is that when we legislate on life and death, we have a duty not only to write laws that are clear, but to ensure that they can be trusted. And as it stands, the Bill contains no mechanism for what happens when an assisted death may have taken place outside the law. There is no mechanism for families to raise concerns, no means to review what has happened, and no pathway to justice if something has gone wrong. Yes, I will. Yep.
I thank Murdo Fraser for doing that. But do we not already have laws that cover such things? So if a family member was suspicious that a death had not occurred naturally, they could report that to the police. It could be investigated. Someone could be prosecuted for that.
Yes, I mean, that is correct. However, this is about, I suppose, a belt and braces approach, and to formalise that position and put something on the face of the bill that makes it absolutely clear what the route is for a family to go down in the event that they have concerns. And I think we're all very much aware of the pressure there is on police and on the justice system and on the Procurator Fiscal Service. So creating a specific mechanism is a way that these concerns can be raised in a much simpler basis. And indeed, when complaints are made, therefore, to the Procurator Fiscal, that they are backed up with the appropriate medical evidence, which is what we're trying to achieve. So what this amendment would... yes, I will.
Yeah, thank you very much. I mean, I'm actually raised a very similar issue in my amendments before, although not through the Procurator Fiscal, because the issue would be around malicious intervention here by other members of the family in terms of moral grounds or whatever to try and prevent somebody accessing assisted dying. I think my concern would be, because I was trying to give it as within a 10-day window, so I would have an independent adjudicator in that particular situation, which incidentally wasn't passed. But would you not, if we brought the Procurator Fiscal into this, do you not think that would then mean that the length of time that might take, the person who is trying to access assisted dying may have already died by the time that comes to fruition?
I think perhaps Mr Whittle is misunderstanding the amendment here, because the amendment here refers to a situation where an assisted death has taken place. This is after the event where the family have concerns that the criteria were not met. So in effect is asking for a review. If the family are concerned, the family will be able to ask for a review of that process at that point. So it wouldn't impact on the situation Mr Whittle's referring to. Yes, of course.
Thank you very much. It's just further on that point that Mr Whittle raised in terms of malicious intent that could happen. I'm just wondering, how would you foresee, if this amendment was to proceed, a case by, where somebody could seek to ask for a review, and that then could open up information that the deceased person maybe wouldn't have wanted that individual to know in terms of their own medical history, issues. They might not have had a loving relationship with that individual. So what safeguarding would you put in that would respect, the deceased person's wishes in amongst that?
Yes, I think that's a reasonable point. And the way the amendment is crafted, it would be a matter for two independent doctors to review the evidence. So there wouldn't be a necessity to discuss that with the person making the complaint. I hope that answers the point that the member's making. So I was going to say, Convener, is two medical professionals unconnected to the death. These would have full access to the medical records and declarations, and if that review found that the eligibility criteria were not met or the law was broken, that case would then have to be referred to the Procurator Fiscal. So the amendment is about accountability, transparency and respect for both the living and dead, and ensuring that, in granting the most serious of powers, Parliament also guarantees the highest standard of oversight. Yes, of course.
I'm grateful. I think Mardo Fraser seems to be coming to the end. So I was wondering if he was going to address why he's specifically chosen to reference family members in this amendment, given that, as the convener earlier pointed out, existing criminal law exists, regulation of the medical professions. If an assisted death was provided today in the absence of this legislation, it would be dealt with by those mechanisms, and those mechanisms will still be available if anybody had a concern that the law had been broken. I'm wondering why he specifically thinks a different mechanism ought to be available if and only if it's a family member who has that concern.
I think because those who have the closest interest in the matter would be members of the family of the person who's opted for assisted death, and therefore they would have the closest knowledge of the individual and the biggest interest in the matter. I mean, one could conceivably extend this to any person, but I think that would be unreasonable to expect a review at the request of any person. I think this is quite narrowly drawn, so it's only the next of kin or family members under the legal definition that originally exists of family members who would have this requirement. I will, yes.
Thank you, Mr Fraser. Does this, I'm thinking that perhaps you might agree that I've been aware of the links with a case in Canada where a family only found out it was an assisted death on the death certificate, and that your amendments would give a means for that family to find out a little bit more if they were concerned? That's a reasonable point that the member makes, that the family would have to have a genuine concern that something had happened which was improper to ask for a review, but that could happen in that case. So, Convener, I think I've taken a lot of interventions. I think I'm at the end of my remarks. I'm pleased to move Amendment 189. I should just say, before I close, I note my colleague Miles Briggs has two amendments in this group, which I would also encourage committee members to support.
Thank you, Mr Fraser. Miles Briggs to move Amendment 200 and other amendments.
Thank you, Convener. These proposals are amendments which I'm taking forward on behalf of BMA Scotland and RCGP Scotland, who represent all branches of practices of doctors who will be associated with carrying out the functions within the bill. The purpose of these amendments is to create a review panel to monitor all assisted deaths as they occur, to ensure that the correct process has been followed, and to make recommendations for how the process and service can be improved, including but not only from a medical perspective. It would ensure that the documentation from each case is brought together and analysed to ensure that compassionate, safe and practical operations of the Act. Review committees are common in other jurisdictions where assisted dying is provided, and having a system of routine monitoring and review of individual cases is important for those providing assisted dying to patients. And patients may want to access this, but also, importantly, for maintaining public trust and confidence in the system. It is normal in healthcare to discuss cases, to take on best practice and learn from experience, and assisted dying service should, if it comes into legislation, be no different. The review panel in my amendment would report to the Chief Medical Officer, and I urge members of the committee to support these amendments, Amendment 200 and 214 in my name.
Mr Briggs. Liam MacArthur.
Thank you. Can I start by thanking Murdo Fraser and Miles Briggs for talking through their various amendments. The bill, I would suggest, contains offences relating to coercing or pressuring a terminally ill adult into requesting assistance, and also provides that it is not a crime to provide assistance under the provisions of the Act, and that there is no civil liability either for doing so. It therefore follows, as you yourself suggested, Convener, in your intervention, that there remains criminal and civil liability if a person is provided with assistance out with the provisions of the bill. If any person believes that another person has been provided with assistance who has not been eligible for such assistance to be provided, then it is a criminal matter and should be reported to police and investigated by the relevant authorities. I appreciate the point that it may more often than not be family members who may have such concerns, but I don't think we could say that it need be reserved entirely to them. It's perhaps also worth reflecting here that on the Stage 1 evidence taken regarding the role of the Crown Office Scottish Fatalities Investigation Unit in investigating fatalities on behalf of the Lord Advocate, and the view of the COPFS that independent scrutiny would already exist. As members will recall, the committee heard at Stage 1 about the role of the unit in investigating all deaths in Scotland, which are sudden, suspicious, unexpected or unexplained. Indeed, the head of the investigation unit set out the independent scrutiny of the circumstances of death that currently exists, covering not only potential criminality, but wider investigation to establish any systemic issues or issues of public concern requiring further investigation. COPFS also confirmed to the committee that medical practitioners are already provided with guidance on those deaths that are required to be reported to the Crown Office. I note the Scottish Government highlighted various drafting and resourcing issues in relation to Amendment 189, and I would urge Murdo Fraser not to press this to a vote. On Miles Briggs' Amendment 200, which would establish an assisted dying review panel to review if the Act was complied with in each case and analyse information provided. I would certainly agree with the points that Miles Briggs made in relation to the importance of learning from the way in which the Act is developing. I think some of the data gathering that we've referred to in earlier groupings will help facilitate that. So I'm not imposed in principle, but I'm concerned that any such oversight panel or similar may duplicate existing roles or processes. I've already touched on and set out in detail the evidence from COPFS and the responsibilities of the Scottish Fatalities Investigation Unit. The Scottish Government also noted that Amendment 200 seemed to cover at least a similar role as that provided for in Section 27 of the bill, and noting that Amendment 214 is consequential to Amendment 200. So at this point, I don't believe that the review panel necessarily adds additional layer of safeguard. I think there may be elements in what Miles Briggs has been trying to get at with that review panel that may be helpful in augmenting what's already in Section 27. But at this stage, I would encourage the member not to move that amendment and for the committee not to support it. Thank you.
Adopt and press or withdraw Amendment 189.
Amendment 189, but if members are not inclined to support that, and encourage them to support the amendments in the name of Miles Briggs.
The question is that Amendment 189 be agreed to. Are we all agreed? Committee's not agreed. We'll go to a vote. Those in favour of Amendment 189? Those against? Abstentions? The result of the vote on Amendment 189 is 1 for, 6 against, 1 abstention. Therefore, the amendment is not agreed to. Call Amendment 39 in the name of Liam MacArthur, already debated, with Amendment 151. Liam MacArthur to move or not move?
Moved.
The question is that Amendment 39 be agreed to. Are we all agreed?
No.
Committee's not agreed, so we'll move to a vote. Those in favour of Amendment 39? Those against? Abstentions? The result of the vote on Amendment 39 is 4, 7 against 1. There were no abstentions, therefore the amendment is agreed. I call Amendment 190 in the name of Jeremy Balfour, already debated, with Amendment 151. I remind members that if Amendment 190 is agreed to, I cannot call Amendment 40 due to preemption. Pam Duncan-Glancy to move on behalf of Jeremy Balfour or not move?
I've been asked to move, Convener.
The question is that Amendment 190 be agreed to. Are we all agreed? Committee is not agreed. So we'll move to a vote. Those in favour of Amendment 190? Those against? Abstentions? The result of the vote on Amendment 190 is 0 votes for, 8 against. There were no abstentions. The amendment is therefore disagreed with. I call Amendment 40 in the name of Liam MacArthur, already debated, with Amendment 151. Liam MacArthur to move or not move?
Moved.
The question is that Amendment 40 be agreed to. Are we all agreed?
No.
Committee is not agreed, and we'll move to a vote. Those in favour of Amendment 40? Those against? Abstentions? The result of the vote on Amendment 40 is 7 for, 1 against. There were no abstentions. The amendment is therefore agreed. I call Amendment 11 in the name of Daniel Johnson, already debated, with Amendment 151. Daniel Johnson to move or not move?
Moved.
The question is that Amendment 11 be agreed to. Are we all agreed?
Yes.
Committee is agreed. I call Amendment 248 in the name of Paul Sweeney, already debated, with Amendment 151. Paul Sweeney to move or not move?
Move, Convener.
The question is that Amendment 248 be agreed to. Are we all agreed? Yes. The committee is agreed. I call Amendment 41 in the name of Liam MacArthur, already debated, with Amendment 151. I remind members that if Amendment 41 is agreed to, I cannot call Amendment 191 due to preemption. Liam MacArthur to move or not move?
Moved.
The question is that Amendment 41 be agreed to. Are we all agreed?
No.
Committee is not agreed, and we'll move to a vote. Those in favour of Amendment 41? Those against? Abstentions? The result of the vote on Amendment 41 is 7 for, 1 against. There was no abstentions, and the amendment is therefore agreed. Thank you. The question is that Amendment 192 be agreed to. Are we all agreed? Oh, apologies. I call Amendment 192 in the name of Jeremy Balfour, already debated, with Amendment 151. Pam Duncan-Glancy to move or not move?
I've been asked to move, Convener.
The question is that Amendment 192 be agreed to. Are we all agreed? Yes. 2. One was 192. Yes. I'll ask that question again. The question is that Amendment 192 be agreed to. Are we all agreed? Committee is not agreed, so we'll move to a vote. Those in favour of Amendment 192? Those against? Abstentions? Thank you. The result of the vote on Amendment 192 is 7 for, 1 against. There were no abstentions. The amendment is therefore agreed. And the question is that Section 18 be agreed to. Are we all agreed? Thank you. I call Amendment 16 in the name of Daniel Johnson, already debated with Amendment 151. Daniel Johnson, to move or not move?
Moved.
The question is that Amendment 16 be agreed to. Are we all agreed? Committee is not agreed. We'll move to a vote. Those in favour of Amendment 16? Those against? Abstentions? The result of the vote of Amendment 16, for, there were 3, against 4, and there was 1 abstention. Therefore, the amendment is not agreed. Call Amendment 20 in the name of Daniel Johnson, already debated with Amendment 151. Daniel Johnson, to move or not move?
Moved.
The question is that Amendment 20 be agreed to. Are we all agreed? Committee is not agreed. We'll move to a vote. Those in favour of Amendment 20? Those against? Abstentions? The result of the vote on Amendment 20 is 4, 3, against 4. There was 1 abstention. Therefore, the amendment is not agreed. I call Amendment 52 in the name of Jackie Bailey, already debated with Amendment 151. Jackie Bailey, to move or not move?
Moved.
The question is that Amendment 52 be agreed. Are we all agreed? Committee is not agreed. We will therefore move to a vote. Those in favour of Amendment 52? Those against? Abstentions? The result of the vote on Amendment 52 is 4, 2, against 5. There was 1 abstention and the amendment is therefore not agreed. Call Amendment 193 in the name of Jeremy Balfour, already debated with Amendment 151. Pam Duncan-Glancy, to move or not move?
Ebenez, to move.
The question is that Amendment 193 be agreed. Are we all agreed? Committee is not agreed. We'll move to a vote. Those in favour? Those against? Abstentions? The result of the vote of Amendment 193 is 2 for, 6 against. There were no abstentions. The amendment is not agreed. Call Amendment 194 in the name of Miles Briggs, already debated with Amendment 151. Miles Briggs, to move or not move?
In light of further discussions at stage 3, not moved.
I call Amendment 195 in the name of Miles Briggs, grouped with Amendments 53, 53A and 53B. Miles Briggs, to move Amendment 195 and speak to all amendments in the group.
Thank you, Convener. And this proposal, again, is from the BMA Scotland. And it's quite a sensitive issue in the sense of sensitive conversations which people will have with their GP. And the amendment comes in two parts. Firstly, that there's no duty for doctors to raise assisted dying with patients, and then no prohibition of doctors raising it with patients. Similar provisions are included in legislative proposals in other parts of the UK and Crown dependencies. And I note the Health and Sport Committee recognised the need to further explore the wording of the bill to provide that legal clarity and protections for medical practitioners, whether they choose to raise assisted dying with their patients or not. The first part of the amendment addresses concerns BMA Scotland members have with the scope of information that must be provided when discussing treatment options with a patient. It is BMA Scotland's view that assisted dying is not a treatment option in the conventional sense. Therefore, the Supreme Court judgments of Montgomery versus NHS Lanarkshire 2015 concerning the scope of information that must be provided when seeking consent to treatment, and McCulloch versus NHS Forth Valley 2023, which provides doctors the duty to raise treatment options with patients, are not relevant here. However, there is no guarantee that a court would take the similar and same view should a complaint be made because a doctor did not raise the option of assisted dying. For the avoidance of doubt and to provide further clarity, doctors would like to see a specific provision within the bill that there's no duty on doctors to raise assisted dying with their patients. Doctors must be allowed to use, I believe, their clinical and professional judgment to decide if discussing assisted dying is appropriate based on the individual's needs of each patient whenever they are within and wherever they are within their treatment journey, as well as both their mental state and their emotional state as well. We cannot risk having a system where every doctor a patient sees brings up the question of assisted dying because they are fearful of being criticised if they do not do so. Equally, BMA members would not want to be prohibited from raising assisted dying where that is right for an individual patient. And this forms the second part of my amendment. This was discussed as part of an early amendment from Pam Duncan-Glancy around the prohibition of doctors raising assisted dying. And doctors should be able to talk to their patients about all reasonable and legal available options. A provision that limits or hinders open discussion about any aspect of death and dying is likely to be detrimental to patients' care and would prevent doctors being able to deliver. Yes. Yep.
I thank Miles Briggs for giving way. I'm very supportive of Mr Briggs' amendment. Fundamentally, some of my issues with this legislation is that it could change that doctor-patient relationship and not be compelled to raise assisted dying. I think it's a really important protection, but I'm just wondering, clearly you don't want to restrict GPs, for instance, from being able to raise assisted dying if they feel it's appropriate, but should GPs be exploring palliative care options first, pain management first, looking at social care provision that could be improved first, before they then raise the subject of assisted dying? At what point during that conversation should GPs raise it, or should that simply be left to their professional judgment also?
I think for most doctors I've spoken to around these amendments, it's been that professional judgment that they know their patients best. And depending where someone is on whatever pathway, be it if they have a 6-month terminal diagnosis for whatever condition and comorbidities, which I think is important to often look at this, they will be dealing sometimes on a daily basis with that patient, and so will want to know whether or not it's appropriate for them to raise that. So I hope this will provide that clarity to professionals, and that's why BMA members have discussed how some patients find it difficult to bring up sensitive subjects in their consultations. And doctors, I do believe, are skilled at reading between the lines of what a patient wants to say. Yes.
Thank Miles Briggs for taking an intervention. I'm really struggling with this. Not your amendment and such. I'm struggling with the thought process that doctors would actually raise the issue of assisted dying. I can't, from the life of me, think of a situation where a GP would say to a patient, "We've tried everything else. Have you considered?" And I actually, I just can't get my head around the fact that we would be asking or giving GPs the opportunity to have that conversation. I don't even know how they could start that conversation. Are we not taking healthcare into a completely different sphere if we're asking GPs or giving GPs the licence to raise assisted dying?
Well, this would be all medical professionals, and the eligibility of the bill would then be the legal framework they would be looking to have those conversations. And I think that's the circumstances around a skilled doctor gently opening the door to those conversations if they felt that's what that patient would be appropriate to, not then, and allowing that patient to walk through into a safe space where they can discuss what's on their mind, and that eligibility to the bill as is still being debated and looked at would then point towards whether or not a referral can be made. And so I think the prohibition around raising assisted dying ties doctors' hands and creates that uncertainty and legal risks for doctors that would inhibit effective doctor-patient communication and understanding, which all of us will know is important. And that's why this amendment, and I apologise for going off at length, I think is important to look at those sensitive conversations and to make sure that our professionals have that space where they can feel they can raise this. Yes.
I thank the member for taking the intervention, and I'm listening carefully to the points that he's making, and I understand about concerns over a kind of restricting that sort of patient-doctor conversation. But could I ask the member how he would imagine, within this framework that he proposes in the amendment, how would he imagine managing the issue that quality of life of a disabled person or someone who has lost function, which is very likely in the case of people who are considering assisted dying, is often rated much lower by other people and indeed health professionals than it is between the individual themselves. And so there is a risk that somebody could almost imagine that life must be so difficult. Have you considered? Has the member thought about how that could be mitigated within the context of his amendment?
So I think that the creation of the framework is what's important for professionals to firstly assess if the patient in front of them is actually eligible, but also those conversations which they will be able to decide whether or not it's taken forward. And to have that flexibility, it will be, in some cases, patients who have researched this themselves and come to have those conversations. In other cases, and this is why I think that legal framework is important, the medical professionals need that option to feel safe enough if they think it's appropriate to raise that. So it's a juxtaposition. I understand that as an amendment, but I think it's important to provide in the bill that clarity for the medical world. And I move these amendments in my name. Or the Amendment 195, sorry, in my name.
Sorry. Jackie Bailey to speak to Amendment 53 and other amendments in the group.
Thank you very much, Convener. And Amendment 53 has been tabled by myself on behalf of CHAS, which is the Children's Hospice Association Scotland. Can I say I always have sympathy with Miles Briggs, but on this occasion I'm not sure it's the right approach that he's suggesting, because my amendment talks specifically about the difference I think we need to have in this regard when we're dealing with children. I do genuinely believe it would be unethical for medical practitioners to proactively raise assisted dying to young people under the age of 18 as part of anticipatory care planning. Anticipatory care planning is the process where the future care needs of young people with a life-shortening condition are discussed, they're planned for, and the risk of coercion, I think, is high. Healthcare professionals do have a very privileged relationship with young people and their families. They may have known the young person for a considerable period of time prior to the young person becoming potentially eligible for an assisted death. For that medical practitioner to proactively raise assisted dying isn't a neutral act, and it may be perceived as a recommendation, even if presented neutrally. It is, I think, considered that raising assisted dying as an option for young people may also cast doubt upon the efficacy of other treatments or measures, or that family members are struggling to provide support. The reason that coercion is such a worry at that particular time in a young person's life is that they may well be transitioning from child to adult services. That's really difficult. It can be really hard because many of the people they rely on and they know, such as health professionals, social care workers, voluntary sector organisations, are changing. And that makes them particularly vulnerable. This doesn't stop doctors answering questions if they're asked, but it would prevent pre-planning before the age of 18. So I would urge support for this amendment. Sorry, I've just finished, but I'm happy to give way.
If it's okay, thank you very much. I don't think it's likely that anybody would raise this in a way that is a recommendation. I don't think that's certainly not what would be intended. I'm curious, though, about the fact that the amendment says that this can't happen where the subject has not first been raised by the person with the registered medical practitioner. Surely the amendment as written would therefore prevent a child or young person from raising the issue with somebody else, for example, a family member or a professional in a non-medical capacity working with them to support them, saying, I've heard that this is an option, will you ask the doctor to tell me about it? It would then prevent the doctor or the registered medical professional from doing so.
Convener can say that it doesn't do that. What it does is it makes it really clear that it would be up to that young person to make that request, and the doctor can then deal with that. But there are, I think, unintended consequences, because the relationship, if you've seen somebody, a young person with a life-limiting illness, they usually have the same medical team. That person almost becomes like a family member. So something said can be perceived as a recommendation rather than something that is an entirely neutral act. And it is a belt and braces approach to ensure that that doesn't happen. And there are no unintended consequences from this legislation. And I would simply rest on the fact that this is something that Chas think is critically important.
Thank you, Ms Bailey. Daniel Johnson to speak to Amendment 53A and other amendments in the group.
Yes. First of all, can I begin actually by thanking the committee for their forbearance in allowing me to speak remotely. I've been having to do a bit of juggling this afternoon. In terms of the amendments themselves, let me say up front that I think Jackie Bailey's Amendment 53 is very important. Having spent some time around the sick kids in Edinburgh at an earlier stage, one realises that for many families, healthcare settings are home. They're the everyday life. The medical teams are actually part of an extended family. They are having to discuss matters on an ongoing basis that are pretty seamless and very much part of the day-to-day norms. I think the prospect of assisted dying being discussed with young people within that context is hugely problematic, which is why I think Amendment 53 is very important. What my amendments seek to do is extend that a little further. It is about in previous amendment sections we discussed, I think, the differences for those who are facing terminal illness in earlier life. They have different considerations, and the question marks regarding capacity for people up to the age of 25 when brains are forming. This would simply be a measure that would not withhold treatment for those under 25, but just recognising that it needs to be treated differently. Now, what I'm just careful of here is that I think Jackie Bailey's amendment is important in its own right, This is simply seeking to perhaps explore whether there is a lighter touch way of addressing the 25-year-old point by saying not that this would be prevented or people between 18 and 25 precluded from taking assisted dying, merely that it could be proactively raised with them. And to that end, 53A and 53B would give effect to that.
Thank you, Mr Johnson. Liam MacArthur.
Thank you. Again, can I thank Miles Briggs for initiating this debate. When I was listening to him speak earlier on, it reminded me of some of the exchanges that we had way back this morning. I think it was Bob Doris who was playing devil's advocate both for me and for Sue Webber, which I thought was an heroic act on his part. But he talks about the need for a framework, but also the need to protect discretion for medical judgment. And I think in all of this, that's the balance that we need to be striking here. I certainly will.
But, thank you, Mr MacArthur, for taking the intervention. But surely you realise that the relationship that a patient has with their healthcare practitioner, their GP, is unique. That trust is unparalleled. And very rarely do people turn up at their GP or their consultants armed with information about the options that are available to them. And then if doctors were to raise assisted suicide unprompted, it would just completely devastation for that relationship. And I just think that it's not a neutral act. And I think Jackie Bailey spoke at length in relation to young people. And I just cannot imagine, if that was discussed with myself or brought up unprompted, how that could then have any element of trust with me and that healthcare practitioner going forward. You must understand that challenge we have.
I'll allow Bob Dorsey in a second. I mean, I understand what Sue Webber is saying. I would also note that this is a concern that has been raised as a result of representations that have been made by the BMA, who are representing many of these medical professionals. And I think it's a strong argument that the BMA make in relation to many aspects of this bill and indeed other bills going through legislatures around the UK. About the need to make sure that we don't cut across appropriate medical discretion and judgment, that we take care in terms of interfering with the doctor-patient relationship. I think Sue Webber's absolutely right, and I think Jackie Bailey made the same point about how integral that relationship can be, particularly with a terminal illness where probably the patient very often has been under the treatment and with support of not just our medical professional, possibly a team of medical and other professionals. And those relationships are very, very important. But I think important within that is to allow professionals using the training, the experience, judgment that they have to exercise judgment in an appropriate way. I'd offered Bob Doris, but I'll come to you in a second, Mr Whittle. Bob Doris.
Thank you, Mr MacArthur. And thank you, I think, for reflecting on my heroic efforts this morning. I think I should put on the record at this point, I promised a question in this convener, that I agree with Brian Whittle, who said that he can't imagine the situation where the clinician would raise assisted dying. My view would be that to absolutely bar the clinician from doing that would be an undue restriction on the clinician, which is why I think this is a bit nuanced. A framework was mentioned by yourself and Miles Briggs. My issue is that this morning I tried to bring in amendments to create that framework, and each of those amendments unfortunately did not find sway with the committee. And I hope what happens with this exchange opens up space at stage 3 to put some of that framework on the bill, which I think is absolutely required. I wonder how Mr MacArthur feels about that.
Again, I think, as I said, the point that Bob Doris was making then and now about the importance of framework, I don't disagree with. I mean, where we perhaps would disagree is the extent to which there is a framework there. But that is part of the process of stage 2 and indeed stage 3 to see whether, even if there is a framework there, is it something that we need to buttress further. But within that, whatever framework we set, I think we still need to allow scope for that clinical judgment based on appropriate training. And again, we've covered some of the training aspects that are linked to this bill, and I think there are areas there where perhaps further strengthening might be required. But all of that, I think, speaks to the need to allow that judgment to be exercised. Brian Whittle, sorry.
I have to say, I'm incredibly uncomfortable with the direction of travel in which this conversation has gone. I'm listening to the interventions and the presentations from colleagues. I can see no circumstances where a GP would be able to raise the subject of assisted dying in the first, and two seconds, an intervention on an intervention. I like that. Because, as Jackie Bailey highlighted, there is a unique relationship between a patient and a doctor. And a GP raising assisted dying in of itself, I would suggest, is a form of coercion. And I cannot see a single situation where a GP could be the one to raise assisted dying.
Thank you, Mr. Whittle. I'm set in a context because I think from speaking to the medical practitioners who want this legal clarity, if you were a GP and I came in and said to you, I have a terminal condition, I want to go to Switzerland, I want to go to Dignitas, how would you then provide the information to me about what's potentially, if this bill does pass, legally available in Scotland? And that is a real-world experience of probably professionals having this raised.
Intervention in my intervention. Thank you. In that circumstance, the patient has raised assisted dying, not the GP. I think that's the key here. I cannot envisage any situation where it's appropriate for a GP in the patient-GP relationship, for the GP to raise an issue, to raise the issue of assisted dying. I can't see that.
For the sake of absolute clarity, because we're talking about GPs here, and I can understand that, but your actual amendment speaks about medical practitioners. So in that case, that would perhaps cover a palliative care doctor, where a patient says, what are my options? I'm in a lot of pain, or I'm facing losing the ability to swallow, or a risk suffocation. What are my options? And your amendment would then give that medical practitioner, broader than GPs, the leeway to be able to say, these are your options. It could be this medication, that medication, or you could look at.
Yeah, and for clarity, it's for all doctors who would be operating within the scope of the bill. I think that's important, that legal clarity and also protections for medical practitioners, whether or not they choose to raise assisted dying, is available. And I think that's where it's an important ask of the medical professionals, if this bill does go forward, that this is on the face of the bill.
Clarity there, Mr Briggs, and I think that was really important. Mr MacArthur.
That has been very helpful, if slightly unusual for these proceedings. I mean, it's probably worth reiterating that the bill is predicated on a terminally ill adult requesting assistance to begin the process. I think in the point in relation to Dignitas that Miles Brigg referred to, in terms of his amendment, because that isn't a procedure that's covered by the Act, there wouldn't be a protection there. So to some extent, that issue still remains pertinent. As I say, I think allowing discretion, medical judgment to apply, not creating an environment where assistance under the Act becomes stigmatised and which is not subject to free, open and transparent consideration, is again something I think we need to avoid. I think the bill as it stands almost certainly covers that. It seems to me to some extent that Miles Briggs' amendment may be more of for the avoidance of doubt, but I think the debate we've had around the amendment, if nothing else, has demonstrated the need for perhaps greater clarity around that, and I'm certainly sympathetic to that. Turning to Jackie Bailey's amendment 53 and Daniel Johnson's amendments 53A and 53B, I note that Sanders Golhani's amendments, which change the eligibility age from 16 to 18, have been agreed to, meaning that no person under the age of 18 will be eligible to request assistance under the Act. I've also previously set out why I'm not supportive of changing the eligible age limit to 25. As I've made clear, the bill does not require, neither does it actively permit any health professional from first raising assisted dying with a person, and is predicated on a terminally ill adult requesting assistance to start the process. That said, and I think in relation to some of the earlier amendments that Jackie Bailey either lodged or was speaking to, I absolutely accept some of the arguments that she and Chas have been making about the way in which this process will almost certainly in every instance be very different to the process for somebody in later life with late stage cancer, whatever it may be. I think that said, I'd ask members to consider whether the amendment is necessary, given that those under 18 are not eligible to be provided with assistance, and I suppose the same factors apply in relation to Daniel Johnson's amendments. So again, the rationale for introducing them, I think, does go to the point which I have accepted before, that the training that will be required for those practitioners is likely to be different to that for other patients at a later stage, and indeed some of the way that the process works in practice almost certainly will be different, not least because it is likely to involve a wider team of not just medical practitioners but social work and other experts in particular fields. So, as I say, with those observations about the age limit that we've already discussed, I have no strong views on those amendments.
Miles Briggs, to wind up, in place of withdrawal, Amendment 195.
I don't have anything further to add. BMA Scotland, who I've been working with on a number of amendments, are very much in favour of making sure that they have this legal clarity. So I'll move this amendment in my name.
The question is that Amendment 195 be agreed to. Are we all agreed? Yes. No. Committee's not agreed. Those in favour of Amendment 195? Those against? There's no abstentions. The result of the vote on Amendment 195 is 4-7, 1 against. There were no abstentions. The amendment is therefore agreed. Call Amendment 249 in the name of Stuart McMillan, already debated with Amendment 151. Stuart McMillan, to move or not move? The question is that Amendment 249 be agreed to. Are we all agreed? Committee is not agreed. We'll move to a vote. Those in favour of Amendment 249? Those against? Abstentions? The result of the vote on Amendment 249 is 2-4, 6 against. There were no abstentions. The amendment is therefore not agreed. And the question is that Section 19 be agreed to. Are we all agreed? And at this point, I'll suspend the meeting until 19:30. I call Amendment 250 in the name of Stuart McMillan, grouped with Amendment 251. Stuart McMillan to move Amendment 250 and speak to the other amendments in the group.
Thank you, Convener. So, Section 20 of the bill is designed to ensure that if a person helps someone to end their own life in accordance with the processes set out in the bill, that they could not be sued for doing so. The Salvation Army, with whom I've worked with on this amendment, want to ensure that if a person helps someone decide not to end their own life, they also would be equally protected from being sued. This may seem unlikely, but it's a hypothetical situation. After the bill passes into law, a terminally ill adult is thinking of seeking assisted dying. They discuss the possibility with people that they trust. As a result of one of these discussions, the person changes their mind and decides not to seek assisted dying, but to let the illness take its course. Some members of the family don't agree with the decision to do this. They do not understand how they could have changed their mind and chosen a longer death, with which they think was less dignified and perhaps more costly because of care expenses than assisted dying actually would have been. After the individual dies, family members blame the person who they had the discussion with for persuading them, as they see it, to choose a way of dying that they believe was not in the best interests of the now deceased person. So they try to sue the person for having made the relative's death more distressing than, in their view, it could have been and should have been. No one knows how the court would respond to this type of case. It might decide that the claim cannot succeed or that there are no legal grounds for bringing it, but no one can be sure. So the Salvation Army proposed these amendments to make sure that the claim could not be made. These amendments are not about seeking special protections for anybody. It's about equal protection before the law. It would be perfectly reasonable for a terminally ill person who is thinking about seeking assisted dying to discuss the question with family, friends and other persons with whom they trust. What is being sought is to be sure that everyone who is part of those discussions can exercise the privilege and responsibility of doing so without fear that a civil claim might later be made against them, so long as they can act honestly, in good faith and otherwise in accordance with the law. The bill, as it's drafted, gives that protection to people who help a terminally ill adult end their life. These amendments are seeking the equal protection should be given for those who provide advice to the contrary. Thank you.
Thank you, Mr McMillan. Liam MacArthur.
Sorry, Convener.
Thanks, Stuart McMillan.
Can you move your amendment? Apologies.
Yeah, to move Amendment 250 and 251.
Thanks, Convener. Again, thanks, Stuart McMillan, for setting out the rationale behind his amendments, and certainly would echo his point about the importance of the openness of the conversations that I think ideally should happen. I think we've had quite a bit of discussion in earlier groupings in relation to anticipatory care plans, and I think underlying all of this is the desire to see more people take more care and attention in setting out their wishes and discussing those with loved ones, family, friends, whatever, as early as possible. I've also engaged with the Salvation Army, although much earlier on in the process and not specifically in relation to this issue. I'm not aware of the issue having been raised at stage one or indeed in the consultation on my proposals way back in 2021. I also note that in Scotland, unlike in England and Wales, there is, of course, no specific statutory offence of assisting somebody's death. Therefore, consider that the Bill's provisions are sufficient in terms of protecting civil liability and would urge Stuart McMillan on that basis not to press his amendments, although, as I say, I'm not cited on more of the background to this that Salvation Army may be able to help me with, along with Stuart McMillan. So I'm happy to continue those discussions, but at this stage I don't see the need for those amendments. Convener.
Stuart McMillan to wind up and press or withdraw Amendment 250.
Thank you, Convener. I thank Liam MacArthur for his comments and also acknowledging that also what's behind these amendments. Certainly the dialogue I did have with the Salvation Army, I genuinely didn't fully take on board the issue initially, but I'm also conscious that certainly without the discussion that we did have, I recognise that we don't know what's ahead of us, and also that the law can change. So the purpose of these two amendments was really just about a safeguarding to protect individuals who obviously may or may not get involved in that type of dialogue going forward. So it really is just about a safeguarding.
Mr. McMillan, I appreciate that, and as you'll be aware, there have been a number of, for the avoidance of doubt, provisions that we've added to the bill through various amendments. So I'm certainly not averse to doing that, but I think certainly from my perspective, I would need maybe a better understanding of what we're seeking to achieve with that. Even if it's for avoidance of doubt, there is potential risks that you cause more confusion in trying to go down that route. But that offer is there.
Can I come back in, Convener?
Yes, I'm looking for you to press or withdraw your amendment.
Well, if Mr MacArthur is content to have further dialogue, I'm content not to press the two amendments at the moment, but potentially could do so at stage 3, depending on that conversation with Salvation Army, if he's okay with that. Okay. I'll withdraw at the moment, yes, thank you.
Does any member object to Mr McMillan withdrawing the amendment? The question is that section 20 be agreed. Are we all agreed? I call amendment 62 in the name of Jackie Bailey, already debated with...
Sorry, apologies, can you 251?
Mr McMillan said he withdrew both.
But he's not moved it yet.
So you need to move the amendment to withdraw it?
No, or not move it.
So, okay, amendment 251. I call amendment 251.
Not moved.
Thank you. The question is that section 20 be agreed. Are we all agreed? Yes. I call amendment 62 in the name of Jackie Bailey, already debated with amendment 148. Jackie Bailey to move or not move?
Moved.
The question is that amendment 62 be agreed. Are we all agreed? Committee's not agreed. Those in favour of amendment 62? Those against? Abstentions? The results of Amendment 62 is 4 for, 4 against. There were no abstentions. Therefore, I cast my casting vote in favour of the amendment, and the amendment is agreed. Call Amendment 127 in the name of Patrick Harvey, already debated with Amendment 173. Patrick Harvey to move or not move?
Not moved.
I call Amendment 53 in the name of Jackie Bailey, already debated with Amendment 195. Jackie Bailey to move or not move?
Moved.
I call Amendment 53A in the name of Daniel Johnson, already debated with Amendment 195. Daniel Johnson to move or not move?
Not moved.
I call Amendment 53B in the name of Daniel Johnson, already debated with Amendment 195. Daniel Johnson to move or not move?
Not moved.
Jackie Bailey to press or withdraw Amendment 53.
Pressing.
The question is that Amendment 53 be agreed to. Are we all agreed? Yes. No. Committee's not agreed. There will be a vote. Those in favour of Amendment 53. Those against? Abstentions? The result of the vote, Amendment 53 is 7 for, 0 against and 1 abstention. The amendment is therefore agreed. Call Amendment 42 in the name of Liam MacArthur, already debated with Amendment 220. Liam MacArthur, to move or not move?
Moved.
The question is that Amendment 42 be agreed to. Are we all agreed? Yes. Committee's agreed. I call Amendment 43 in the name of Liam MacArthur, already debated with Amendment 220. Liam MacArthur, to move or not move? The question is that Amendment 43 be agreed to. Are we all agreed? Committee's agreed. The question is that Section 21 be agreed to. Are we all agreed? Call Amendment 252 in the name of Pam Duncan Glancy, grouped with Amendments 253 and 276. Pam Duncan Glancy, to move Amendment 252 and to speak to all amendments in the group.
Thank you, Convener. Amendment 252 creates an offence of advertising assisted dying. It makes it illegal for any person to publish, distribute or display material that promotes, encourages or solicits assistance for a terminally ill adult to end their life. The definition of advertisement is broad, covering printed, electronic and social media communications, as well as other forms of public or private communication. Penalties include fines on summary conviction and imprisonment of up to 2 years, a fine or both on indictment. These sentences are identical to those proposed in similar amendments at Westminster. The section does not apply to professional or educational communications where no encouragement or solicitation occurs. There is a striking omission, I think, in the bill, in that nothing in it prevents another person from encouraging someone to seek an assisted death. And we've had a conversation on a previous group about the role of health professionals, and I think it's important for us to understand that if we are beginning to try and support people to live, which is what I think we are aiming to do as a Parliament, we need to have these conversations as opposed to conversations about assistance to die. And having just amended the legislation to say that we can include some conversations initiated by medical professionals, I think it is important that we look to prevent the advertisement of assisted dying on any scale. Now, I think that it's not just a small oversight. I think people who come under the scope of the bill are, by definition, at a very difficult and vulnerable point in their life. It could be physically, emotionally, or indeed psychologically. They often have immense trust in others, including medical professionals, family members, carers, believing that they have their best interests. But even gentle suggestion or a question asked at the wrong time could have a powerful and dangerous impact on someone who might feel like a burden or is struggling to find hope. If the bill intends to be about choice, as advocates say it is, then I think that choice must be free from pressure, persuasion or professional suggestion. Anything less risks crossing the line, I think, from autonomy to influence. This amendment provides that safeguard. It makes clear that any request for assisted death must be entirely self-initiated by the individual, must not be the result of encouragement, suggestion or inducement. It protects people, I think, from subtle but powerful pressures, spoken or unspoken, that could lead them to see death as an obligation rather than an option. And I'd ask committee members to think about whether or not they can see where an example of where support to assist people to live is advertised, where the great good that can come from having personal assistance and a really good social care plan can be advertised, and where we see advertisements for accessible homes where disabled people are living full and enjoyable lives. These advertisements are few and far between, if even they exist at all. And my argument has always been that in this Parliament we should be doing what we can to legislate and make it easier to choose to live than to die. What this is seeking to do is to say that we can't have adverts that would encourage people to have their life ended, particularly in a context where we rarely see advertisements of a good life with the rights to practical assistance and support that disabled people have in order to participate in society and lead an ordinary life. I'm happy to take the intervention and sorry for the delay.
Thanks very much. I didn't want to interrupt your flow there. I'm sympathetic to this amendment. You mentioned, though, at the start of your contribution, that these are similar to the amendments in the Westminster Bill, I think section 43 of the Westminster Bill as amended. My understanding is that that section of that bill would apply to Scotland, so I'm just wondering whether you've considered if as a, how amendments here would interface with amendments in the Westminster Bill which applies to Scotland.
I thank the member for that intervention, and of course it's important to look at how the bill here interacts with the bill at Westminster, and with both going through at the same time we have to keep these discussions quite live, and I take that point. But I would see no harm in underpinning legislation in Scotland that doesn't contradict what has been done elsewhere, but indeed asserts that the Scottish Parliament mean that this too is to be protected against, and is something that we wanted to guard against within the legislation. And so I see no reason that this would prevent the amendments from progressing. And I'd hope that committee members would consider that advertising could have a subtle but very important impact on people's choices. And in the absence of the encouragement or advertisement of a good life that can be experienced by people who lose function, indeed at the end of life too, I think it would be important that we put in this very important measure to protect against that. I'm happy to take further intervention.
I'm grateful to Pam Duncan-Glassie for giving way. I'm just wondering about the use of the term advertising. That it's clearly there in the subject of this amendment, but the amendment also covers social media posts. Is it Pam Duncan-Glassie's view that a social media post by an individual expressing a view which might be found offensive would be regarded as advertising in terms of this amendment, and what in the amendment would prevent it from being captured by what's being proposed?
I thank the member for that intervention. No, that's not my intention. My intention is that it would be directive, and so that it would be directive and encouraging someone to actively make that particular choice. And I think that social media is a space where advertisements are used, and in fact a lot of adverts come through social media, and so it's within the regulation of advertisement that I think it's particularly important that we also include social media. Not to include social media, I think, would preclude a large platform that we know many people consume that does of course include advertisement, and so that's why I think it's important that that's included in the legislation. And I think with that, convener, I'll close my remarks there.
Thank you, Ms Duncan-Glancy. Sue Webber to speak to Amendment 253 and other amendments in the group.
Thank you, convener. My amendments 253 and 276 specifically discuss the prohibition of dissemination of information relating to the substances used for assisted dying, because the bill, as it's currently drafted, says nothing about that dissemination of the information concerning the substances used for assisted suicide. There is no prohibition on publishing, on sharing details about what these substances are, where to obtain them, in what quantities they should be used, and I believe that this omission is dangerous. Vulnerable adults who are suicidal could access this information online and attempt to end their own lives, outside the protections, if they are there, and the oversights of this bill. This runs directly counter to the objectives of the Online Safety Act, which seeks to remove the content that encourages or facilitates suicide. In matters of life and death, information itself can be lethal, and we cannot legislate for assisted suicide while leaving dangerous knowledge unregulated. This amendment attempts to close that gap. It prohibits the unauthorised sharing of information about the substances used in assisted suicide, including the composition, sourcing and dosage. So the purpose is threefold: to prevent misuse, to ensure strict ministerial oversight of highly sensitive information, and to maintain public confidence in the safety and integrity of the assisted suicide framework. It is a targeted, responsible measure to protect the vulnerable, uphold professional standards, and prevent the misuse of lethal information. I want to speak briefly on Pam Duncan-Glassie's amendments to... I will.
I'm grateful, before the member moves on to the other amendment, for an intervention on 253, I can entirely see that there are circumstances in which information of the kind Sue Webber is referring to would be inappropriate or would be placed in an inappropriate, made available in an inappropriate place or inappropriate framing. But from my reading of the amendment, it seems as though it would prohibit academic research, for example, unless it had specific approval by Scottish ministers from being disseminated. Can Sue Webber explain in what way does legitimate sharing of information for purposes like that not fall within this amendment?
Thank you, Mr Harvey. I'm hoping if the member might consider some irony here when earlier on our amendments we were looking to collate data on side effects and how patients interacted with these drugs while going and carrying out their own death was challenged, that you might find that perhaps this dissemination of information, when might it not be inappropriate? We're talking here about public dissemination, not through clinical channels which exist right now when people are moving on with medical decisions and sharing of information. And as I said, this is more about attempting the Online Safety Act. You don't find many clinicians sharing their medical practice on TikTok. I want to speak about the amendments that Pam Duncan-Clancy put forward regarding advertising, because it's a practice, advertising, we want to make sure that we do also prohibit the dissemination of the information on services provided as well as the substances, because there can be inappropriate adverts that could happen. You can only envisage some of the gross inappropriate advertising that may materialise if it's not prohibited, subtle or direct, because marketing is extremely powerful and we see that all around us in influencing on social media, and we really need to make sure that we do everything we can to prohibit that. And with that, I conclude my remarks.
Brief intervention on Sue Webber.
Yeah.
I just want to pick up the point that Mr Harvey made about the sharing of information. And in paragraph 4 of your amendment, you talk about making Scottish ministers must, by regulations, make provision for the publication and maintenance of a list of persons or bodies authorised to hold or communicate such information. Within that list, are you thinking about things like universities that teach pharmacy? Are you thinking about pharmaceutical companies? Are you thinking about researchers? Well, I'm just keen to know who you were aiming that particular part of the amendment at.
These are professionals involved in medical and scientific field, and I think, given your comments there, Convener, on that clarification, yes, it would be for those that are seeking to perhaps, and this is challenging for me to make it right, for the substances involved in assisted dying to perhaps make them better. And that's not what I'm meaning, but my earlier amendment spoke about some of the really challenging side effects and substances, and understanding how all these substances interact with the various individuals, because we are all unique after all, and how we interact with medicines.
I suppose, and thank you for taking a further intervention. I suppose I was seeking clarity around about that. About this is about within a professional clinical sphere that information would be shared for. It's not being shared for nefarious purposes. It's being shared for good clinical practice, teaching, education.
Well, yes, that is why that paragraph is there, to allow the appropriate sharing of information, not those that might be deemed as inappropriate and therefore used by those vulnerable individuals, as I've alluded to in my commentary. Convener, thank you very much for your assistance there.
Liam MacArthur.
Thank you. Can I again start by thanking Sue Webber and Pam Duncan-Clancy for speaking to their amendments. I'll turn first to Pam Duncan-Clancy's amendment 252, which seeks to make it an offence to publish, distribute or display any advertisement notice or material which promotes, encourages or solicits the provision of assistance to a terminally ill adult to end that adult's life. I note the amendment also lists examples of advertising, including printed and electronic material and communication, social media posts, websites and any other form of communication, public or private, aimed at reaching more than one person. And Pam Duncan-Glancy's, I think, explained very well the rationale behind that. The amendment exempts communication solely aimed at providing information about this Act and provides for a maximum penalty of a fine at level 5 on the scale or 2 years in prison. I'm aware the committee considered the related legislative consent motion that I think Joe Fitzpatrick referred to, an amendment that was agreed to the Westminster Bill which extended to Scotland a duty on the Secretary of State to make regulations prohibiting the advertising of a voluntary assisted dying service. Unlike the provision in the Westminster Bill which limits the advertising offence to assisted dying services provided in accordance with that Act, it seems to me that Pam Duncan-Glancy's amendment seems slightly more broadly to relate to advertising of the provision of assistance to a terminally ill adult in general. And I do wonder about the potential crossover with the Westminster Bill and any uncertainty that might create. I know the Scottish Government's comments on some of the technical aspects of the amendment as well. But that said, I'm very supportive of the principle behind this amendment, which seems to be seeking to achieve much the same as the Westminster Bill, a change there that I very much welcomed. So I think there must be a way of ensuring that if that is the intent of Pam Duncan-Glancy to make this a sort of an equivalent belt and braces provision through this bill is what we see in the Westminster Bill, I'd certainly be happy to support those endeavours ahead of stage 3. I think there are issues that need to be addressed with the amendment, though, for that to happen. With regard to Sue Webber's amendments 253 and 276, this offence appears at odds with the requirement under Section 7 of the Bill for assessing doctors to discuss with the person requesting an assisted death the nature of the substance. It certainly opens up the potential for creating uncertainties for assessing doctors. I note the Scottish Government's concern that labelling the substance potentially could be interpreted as committing an offence, while it's unclear how someone's access to information could be time limited. I note also the amendment through subsection 1 doesn't appear to be limited solely to publishing. I would therefore encourage Sue Webber not to press the amendments 253 and 276, and if she does, for committee members not to support it. Thank you, Convener.
Pam Duncan-Glancy to wind up, press or withdraw amendment 252.
I thank the committee members for that discussion, and I've listened really carefully, particularly to some of the technical aspects, not least from Patrick Harvey around social media, and also that Liam MacArthur has just set out in terms of the specific provisions in the amendment. If I could just test one particular point with Liam MacArthur, if that's all right, the point on the breadth of the definition and what it is my amendment is seeking to not advertise, if that's the right way of putting it. It is, of course, about the bill, but it's also actually, there is an opportunity here for us to look at whether or not that should be broader. And I actually don't think that it necessarily is unhelpful that it is broad, given that existing legislation can change, given that there could well be a difference between the UK legislation and the Scottish legislation. So I'd be keen to know whether or not that aspect of it would be a bit of a deal breaker at stage 3 if I were to bring it back, or if there are other aspects of the amendment that you think could be tightened up through drafting that could meet with some support.
Look, I think that's helpful by way of I think exemplifying what Pam Duncan-Glancy is seeking to achieve here, which is to go beyond what has already been agreed through the Westminster Bill. I also have to say, and I feel this very acutely, that with the legislation passing through both parliaments simultaneously, there is a challenge that arises from those dual processes. As I say, I think I would have concerns about extending this more broadly in the terms of I think there are concerns about ensuring that people do have access to the information they need in order to make an informed decision. I think there are the evidence from other jurisdictions suggests, for example, that as with so many other aspects of health and care, often those in lower socioeconomic demographics find themselves less able to access services because of that lack of that lack of information. So I get the sensitivities around this. I absolutely support the change that was made to the Westminster Bill and would support that applying through the provisions of the bill that I brought forward. I would be wary about extending it further because I think there could be consequences there that almost irrespective of where you stand on whether there should be a change in the law, I think could be problematic.
I thank the member for offering that intervention in response to my question, which I appreciate. I have to say, though, I think on balance, having heard that, I think it would be probably worth testing this with the committee at this point, because I do think there is a matter of principle as well as detail. And I think the point about that has just been made around the need for information is different to advertisement. And in fact, the amendment does try to deal with that. And I think that we need to make a clear, I believe, a clear statement as a Parliament that advertising is not something that I think we should support, given that any kind of encouragement or suggestion could mean and leave vulnerable people, I think, without key protections. These things are often subtle, but they can be really, really powerful. And so I think it's important for us to make the point at this point that we don't believe advertising assisted dying is something that we should be doing alongside this bill. And of course there may be other opportunities at stage 3 to look at technical details, but I actually think I'm afraid now the question of principle has now come back, and I think it's important that we address that here, and so I will press that amendment.
And Glancy, the question is that Amendment 252 be agreed. Are we all agreed? Committee is not agreed and we'll move to a vote. Those in favour of Amendment 252? Those against? An abstention. The result of the vote on Amendment 252 is 4-5 against 1, and there were 2 abstentions, and the amendment is therefore agreed. The question is that Amendment 253 be agreed to. Are we all agreed? Committee is not agreed. Those in favour of Amendment 253? Those against? Abstentions? The result of the vote on Amendment 253 is 4-1 against 7, and there were no abstentions, and therefore the amendment is not agreed. And the question is that Section 22 be agreed. Are we all agreed? I call Amendment 54 in the name of Jackie Bailey, group with amendments as shown in the groupings. Jackie Bailey to move Amendment 54 and to speak to all amendments in the group, please.
Thank you very much, Convener. And I'm moving amendments on behalf of Hospice UK Scotland, which you will all know represents the palliative care sector in Scotland. So amendments 54, 55, 61 and 64 are a package that is designed to assess and mitigate any impact on the hospice and palliative care sector from the introduction of assisted dying in Scotland. Amendment 54 and consequential Amendment 64 requires an assessment of the impact on palliative end-of-life care services of assisted dying being legalised, and Amendment 61 requires that a report is published prior to assisted dying being available. Amendment 55 sets out the creation of a code of practice on how assisted dying would interact with hospices and other providers of palliative and end-of-life care. And additionally, Amendment 57 requires the 5-year review set out in the original bill to consider the impact of the Act on hospices and other providers of palliative and end-of-life care services. If I can set out briefly the reasons for these amendments, we all know the years of funding pressures that there have been on hospices. They are stretched to breaking point. Demand is rising because we're all getting older and we're suffering from more complex health problems and care needs. Hospices need to be growing to meet that rising demand, but the reverse is actually happening. Their concern is that the bill will represent a significant change to people's choices at end of life, and they want to be sure that all staff and organisations, such as hospices caring for people with a terminal diagnosis at the end of life, will be supported through this change. So Amendment 54 and 55 set out an approach to assess and manage any impact on hospices and other providers. The approach aligns with the committee's Stage 1 recommendation that there needs to be careful consideration of how the bill, if it becomes law, will interact with all other key aspects of end-of-life care provision, including palliative care. The key aim of these amendments is to ensure that assisted dying coming into operation in Scotland doesn't have unintended consequences on palliative care services. Now, we know that palliative care services in other jurisdictions where assisted dying has been legalised have experienced increased demands on time, with resources diverted from palliative care in order to support people and families around assisted dying. So this is about very much a pragmatic assessment where there may be implications for hospices and, of course,
I'm grateful to Jackie Bailey for taking an intervention. The interaction, the interplay between assisted dying and palliative and hospice care in jurisdictions where similar laws have been passed, I think is undeniable. And the evidence that the committee took suggested that actually not only often that led to additional funding for palliative care, but actually the engagement with palliative care was improved as well. And that was a similar finding to the Health Committee in the House of Commons, who undertook an inquiry of 18 months, who came up with similar evidence that there was no signs of a detrimental impact on palliative care.
And I certainly welcome that intervention, and I hope that that ends up being the case. But Hospice UK have advised in their briefing that in other jurisdictions where this has happened, palliative care has suffered. So we need to make sure that that doesn't happen here. And I'm only sharing with you the evidence that they have provided me with. Absolutely.
I thank Jackie Bailey for taking the intervention. I should note, Convener, that I chair the Cross-Party Group on Palliative Care in the Scottish Parliament, and the amendments I've had it has been working in partnership with the Scottish Partnership on Palliative Care. I would stress to Jackie Bailey, probably to Liam MacArthur as well, that the case for more strategic, structural funding embedded in palliative care and the hospice movement in general is absolutely core to a civilised society that we all want to see, irrespective of whether this Parliament passes this legislation or not. So would Jackie Bailey agree with me that whilst there is a variance of views about whether palliative care will be enhanced or undermined by this piece of legislation, the bottom line is we should be supporting palliative care and our hospices irrespective of this legislation?
I have no problem, Convener, in 100% agreeing with Bob Doris. That is not something that happens often, but on this occasion I am delighted that we are in lockstep with each other. I couldn't agree more with his comments. But these amendments are about being pragmatic and making sure that the palliative care hospice sector is protected. Amendment 57 would ensure that the 5-year review considers the impact of the bill on palliative and end-of-life care services. Amendment 64 is consequential to Amendment 54 and requires that there's an initial assessment of the impact of the legislation on palliative and end-of-life care, which should be published prior to the substantive provisions of the Act coming into force. I know that Liam, as the member in charge of the bill, has indicated that he would consider that this delays implementation of the bill. Hospice UK are clear that is not their intention, and they think that this can be done very quickly. And finally, Convener, Amendment 61 requires the report to be published. Thank you.
Thank you, Ms Bailey. Pam Duncan-Glancy to speak to Amendment 258 and other amendments in the group.
Thank you, Convener. Amendment 258 requires Scottish ministers, as soon as practicable after royal assent, to carry out an assessment of the capacity of social care services provided by local authorities and organisations providing social care to support the functions under the Act. To just make members aware, I had hoped that this assessment of capacity could go beyond the ability of the capacity within social care services and local authorities and other providers of social care could go beyond only meeting the functions under the Act. My intention was to highlight the level of difficulty that can exist in accessing social care, which can, of course, be the difference between life becoming tolerable or intolerable. However, given the scope of the legislation, it is drafted specifically to talk about support the functions under the Act, and it is nonetheless, I think, a very useful assessment of capacity that can be done. It specifies that the assessment must, in particular, consider staffing resources associated with the provision of social care services, including the training and support that will be required, and existing funding streams for social care services and organisations supporting disabled people. It requires that ministers lay the report before Parliament, and that within 6 months of the report being laid, Parliament must consider a motion to approve the report. Amendments 280 and 284 provide that the sections cannot be brought into force until that report has been published of the assessment of capacity within social care services. I've said before, and I think it's again important to say, that it to me is very crucial that we send a signal that we are a country that seeks to make it easy to choose to live. And part of that is about, of course, having access to good social care when you need it. And all of us around this room will have our inboxes full of casework where we know that this is just not the case. And if we bring a piece of legislation that seeks to offer perhaps another alternative to someone that could include ending their own life in the absence of capacity in an essential system such as social care that can make the difference between finding life tolerable and intolerable, then I think we could be sending a signal that it could be easier, and in fact, not just a signal, it could then be easier to choose to die than it could to live. And so I think this is a crucial part of bringing in any legislation that we seek to bring in to support people to die. Amendment 287 specifies that the Act may not come into force a day before the date on which legislation is brought forward by Scottish ministers to remove charges for non-residential social care being provided to or which would otherwise be available to terminally ill adults requesting assistance under the Act. Again, similarly to my previous set of amendments, I had wanted this to be broader so that we're looking at the capacity in the social care system so that we can be certain, or as certain as we can be, that a lack of capacity in that system is not impacting on somebody's decision whether or not to continue with a loss of function at any point. I think it's also, and I wanted that to be much broader than just in relation to this bill. It's also important to understand that when the difference between accessing social care and not accessing social care is not only just about the availability of it. For some, it's also about the charges associated with it. And some people can pay in excess of £700–800 towards their social care a week. That can be quite prohibitive. And some people choose to make decisions based on the cost of social care, that mean they deny themselves access to social care, that may, for example, mean they could do some aspects of their life that they previously could do, but can no longer do because they cannot afford to access social care as a result of the charges. Ending non-residential social care charges has been an ambition of the current government for some time. They've not yet delivered it. That's not intended to be a political point. It's the reason, although there's plenty of political points that could be made, but the fact remains they are not yet abolished, and they are still causing some significant concern for people accessing social care. Such a barrier to accessing social care such as this, the cost of accessing social care, shouldn't, I think, be in the way, particularly if we also have legislation on the statute books that give people the option to have an assisted death. And so that's why my amendment seeks to say that we could not bring this in an environment where some people have lost out on crucial social care that can literally be, I can testify to how important that is, and I'm sure members have seen the difference it can make to people's lives. But we cannot have a piece of legislation that is brought into the statute books that could assist people to die while some people are making the choice to do without social care, that puts their life in such a situation where they find it intolerable on the basis that they cannot afford it. That is why I have brought this amendment, to say that we first must end non-residential social care charges. Together, I think these measures speak to one really important point that I've made, and at the risk of labouring said point, it is really important that if we are legislating for people to die, we must also make sure that we are doing so in an environment where the choice to live is also viable. As it stands, given the situation in social care, given the situation with social care charges that can prohibit some people from accessing it as well, I'm not sure that's the case. And these amendments seek to protect against that. And that's why I've brought these amendments in this group. Thank you, Convener.
Thank you. Stuart McMillan to speak to Amendment 259 and other amendments in the group.
Thank you, Convener. Amendment 259 is a substantive amendment, with 281 and 285 being consequential. Now, fundamentally, these amendments provide for a referendum of the Bill's proposals if it is successful at stage 3. Scotland doesn't have a written constitution, but if it did, I would want constitutional matters to be decided by referendums of the people. And I've also, I think, considered the engagement that does take place in other jurisdictions, in Ireland and Switzerland as two examples, as well as elsewhere. I believe that level of engagement is hugely important for that sense of local democracy, particularly when it comes to matters of such importance. As we're aware, obviously, these countries do have had referenda on assisted dying. I would argue that certainly the issue before us in this bill should be considered in that context. As I previously stated during this stage 2 process, technically this is a normal bill. The subject matter is not a normal issue, however, and I'm sure that we could all agree on those 2 points. I have long considered referenda to be essential exercises in democratic activity, long before I was elected to the Scottish Parliament in 2007. Just because there isn't really a tradition of it in Scotland or the UK doesn't mean to say that it's not the right thing to do. Now, I suggested a referendum on assisted dying to friends at the end who were working with Liam MacArthur early in the process, and I met them online on the 12th of November 2021. Now, prior to the committee debate at stage 1, I had over 270 constituents from Greenock and Inverclyde directly contact my office asking me to vote against the bill. In contrast, I had 130 constituents contact me asking me to support it, in addition to also emails I'll have received from elsewhere across the country. But the online situation was very different, where I found that most people actually wanted me to support the bill, with the minority wanting me to vote against. So with the previous bill that came before Parliament, Patrick Harvey's bill, I surveyed over 10,000 constituents in Inverclyde at the time. Now, a slight majority of the respondents wanted me to vote against the bill, and it was around about 54–55%. But I'm sure that every constituency, due to differing demographics, faiths, health inequalities and many other factors, would produce mixed results, notwithstanding the poll undertaken by Dignity in Dying. So I genuinely would have no idea as to what the outcome would be in Inverclyde if a referendum were to take place. Sure.
I'm grateful to the member for giving way. Just on one minor point for clarity, that the previous bill that he refers to was a bill introduced by Margaret MacDonald, and as the second member in charge, I took it through the committee process at stage 1. I'm just wondering, clearly, Stuart McMillan is quite correct that there's a wide range of strongly held views on this issue. It's a contested and a difficult issue. It's not the only such contested and difficult issue. In the past, we've had campaigns calling for issues affecting my human rights, my community's human rights, to be subject to referendum, including one attempt to stage a mock referendum funded by a private individual. I've no doubt that in future, if the next session of Parliament, for example, was to legislate on the recommendations on reform of abortion care, there may be those calling for that to be subject to a referendum. For similar reasons to those that Stuart is setting out here, I'm just wondering if he was successful. I'm not convinced of the case he's making, but if he was successful at persuading Parliament to authorise a referendum in this case, how would he then say no to the many other potential cases where the rights and freedoms of minorities, marginalised minorities, which are contested in society, there would be campaigns to put those to a referendum? How would he resist those kind of much more provocative attempts to marshal the same argument?
Okay, certainly, until there would be some type of written or formalised constitution, then it would, issues would have to be raised upon on an issue-by-issue basis. But also the fact that we have this Parliament, and it would then be up to the politicians of the day to agree or not as to whether a referendum should or shouldn't take place on any issues going forward. Did you want to come? No, okay. Certainly, convener. I mean, I think it's common knowledge that there have been some colleagues from across the chamber who voted for the bill at stage 1, but who were quite clear about reserving the right as to whether the bill, but they would offer that support later in the process, depending on amendments at stage 2 and also stage 3. And for me, I genuinely feel as if that if a referendum were to take place, I believe that would be a genuine reflection of a citizens' assembly. Now, I note the Scottish Government's consideration on what the question would be, obviously with the documentation that's on the committee website, the committee page, but I don't for 1 minute believe that it's a realistic concern with regards to kind of any type of fair or unfair question. I made kind of one suggestion. Do you support the provisions in the Assisted Dying for Terminally Ill Adults of Scotland Bill as passed in the Scottish Parliament on whatever date? Yes or no? That's not a leading question. Obviously, other suggestions could be available. On the aspect of timescale, I thought if the bill were to pass, clearly it would be at some point early in 2026. No referendum could take place before the Scottish election. And to have any type of referendum to take place within the first 2.5 years of the next parliamentary session would be, for me, I thought was a logical timescale. But obviously, if it would happen in the early part of that 2.5 years, then that would be fine as well. I'm very relaxed about that, as long as it would be within that period of time. But otherwise, I'm happy to end there.
Thank you, Mr McMillan. Daniel Johnson to speak to Michael Mara's Amendment 260 and also to the Amendment 18 in his name.
Thank you very much, Convener. There are 3 groups of amendments that I'll be speaking to in this section. The amendments 260, 282 and 286 in Michael Mara's name, the amendments 18 and 19 in my name, and then lastly 271, 272, 14 and 15. And I sort of note at this point, I think I've spoken to more amendments in my colleague's name than I have in my own. I think members should intimate to them rather than to myself whether that's been effective or not. It would be simply upsetting if they did so directly. But to 260, Michael Mara has tabled this amendment with a view to looking at the resource implications of implementation of this bill. This is modelled on amendments that have been tabled in the Lords to Kim Ledbetter's bill, which is proceeding through Westminster. And the aim is to ensure that there's robust financial oversight and scrutiny before the Act is implemented. As we have been looking at throughout Stage 2, there are a number of duties, considerations and undertakings that this bill establishes should it pass into law on the many individuals and also services that might be involved. I think we're also very much aware in this place that these are self-same services are not always overburdened in terms of their finances and resources. Indeed, they're in very many cases stretched. So therefore, I think it is important that we look at what the impacts will be on public services, whether that's the health service through to local government and social services. And that is what Amendment 260 seeks to do, and establishes those duties, both in terms of making those assessments and for government to provide a report on the findings of those of that review. Amendments 282 and 286 are consequential to 280. Second group of amendments are 18 and 19. These amendments would seek to set up a commission to provide oversight of the implementation of the assisted dying bill were it to become an act. Again, I think there's been much discussion about what is right and proper to be putting on the face of the bill, and to what extent things should be left to practice, procedure, training and guidance. I do believe, quite rightly, that many of these matters are a matter of judgment and practice. It is right, I think, that much of the implementation of this should be left to those sorts of detail. But I also think, and it's just been alluded to, this is not a normal bill and this is not normal public policy. I think some of the detail, some of the, indeed, subtlety and nuance is incredibly important. And yet we know in this place that scrutinising, let alone amending, anything that is in the form of guidance or secondary legislation is incredibly difficult. So this amendment would set up a commission, a cross-party commission, to sit independently that would provide oversight and guidance to government in terms of drawing those things up. It wouldn't provide a veto, but I think it would provide a mechanism by which that oversight in terms of these quite important details are provided for legislation that is particularly sensitive with that in that regard. Finally, amendments 271, 272, 14 and 15 relate to the creation of a sunset clause. And I note the committee's recommendation that such a sunset clause should be considered through the amending stages for this legislation. And I think this is an important feature. I think I'm not normally someone that has much time for the thin end of the wedge type arguments. But I think on such an important bit of legislation, we do need to provide some guarantees to people that should such a situation arise, should this legislation end up leading to unforeseen circumstances or expanding in ways in which we had not intended when passing this legislation, I think having that emergency brake, that release valve, that sunset clause is very important. That being said, I was not entirely clear on precisely what length of time would be appropriate. So the original Amendment 14 set a time period of 5 years, but I recognise that might be too short. So what I've tried to do is create a set of options for the committee. So that in terms of the sequencing of these amendments, 271 will be taken first, which would give the option of creating a sunset clause at 15 years. Then second, 272, which would create a sunset clause at 10 years, and then finally 14 5 years. And then finally, Amendment 15 just establishes that it would apply the affirmative procedure, i.e. that there would have to be a parliamentary vote in order for the legislation to continue. And that would be a one-off decision by the Parliament. It's not one that would reoccur or repeat. But hopefully that provides the ability for Parliament to have a say to ensure that what was intended was what had come into effect, and provide that reassurance to people that have concerns about where this legislation may end up in terms of its effect in future years. And I'll close there.
Thank you, Mr Johnson. Miles Briggs to speak to Amendment 21 and other amendments in the group.
Thank you, Convener. I think somewhere in these 37 amendments, we're all trying to probably achieve the same thing, but I will start my comments in relation to members will be aware in March 2024. I consulted on a proposal for a Members' Bill to give people of all ages living with terminal illness and residing in Scotland legal right to palliative care, and I'm grateful to Marie Curie and others for their support with that consultation, which is in my register of interests and support received. And to go back to a point Bob Doris made earlier in relation to the cross-party group on palliative care, a lot of the conversations in the Parliament about where our palliative care sector currently is at and the support and additional investment it needs are really important. And I'm disappointed that I've not been able to use this bill to progress some of, to use this as a legislative vehicle in establishing that right to palliative care, which I know many people would support. And the amendments I've tried to pursue around that have been deemed inadmissible. But I haven't given up. So amendments 21 and 22 therefore provide for the reporting on referrals and discussions with individuals around social care services, accessing palliative care services. And then specifically an amendment which I think can help progress the arguments, Amendment 23, which will provide a review and assessment by ministers on the availability of palliative care services. I'm very grateful for those who have engaged with my proposal for a Members' Bill to give a legal right to palliative care, and hope that with the election less than 6 months away, that the consultation and the debate around this bill will also look towards the next Parliament, and I hope influencing all parties in our manifestos for that election, impressing the need for a new funding model has been raised, and also a vision for palliative care services in Scotland as well. And so I move amendments 21, 22 and 23 in my name.
Paul Sweeney to speak to Amendment 269.
Thank you, Convener, and I beg to move that Amendment 269 form part of the bill. This would strengthen the practical framework for administering assisted dying safely and responsibly. The amendment would require the Scottish Ministers to provide necessary structure for medical professionals so as to be able to respond to side effects or even failed medication. Without this, clinicians could face serious medical legal risk problems that arise during the final stages of the assisted dying process. This amendment would ensure that issues of safety are captured and analysed to inform ongoing review and improvement of the assisted dying service. So by passing this amendment, it would strengthen the practical framework for administering assisted dying safely and responsibly.
Thank you, Mr Sweeney. Murdo Fraser to speak to Amendment 199 and other amendments in the group.
Thank you, Convener. I have two amendments in this group, 199 and 203. 199 deals with the issue of independent oversight, proposing the creation of an assisted dying safeguards and oversight body. And I'm grateful to Daniel Johnson for making the arguments why some independent oversight is required, although I think my solution is better than his, because what he is proposing is effectively as a parliamentary body to oversee operation of the bill, and I am proposing an independent body, and members will see from the wording of the amendment how that would be made up. And the reason this is necessary, is, as Daniel Johnson alluded to, is that the bill as it stands relies entirely on internal reporting and ministerial review, but does not provide for a permanent independent authority charged with monitoring
how the bill will operate in practice, ensure compliance with safeguards or investigate when things go wrong. And when we're dealing with a new law in relation to life and death, I think it is essential that we have these safeguards in place. Indeed, as we've seen in other jurisdictions, Convener, where such oversight is missing, then we do see the risks of the slippery slope, where regulations become loosened over time, eligibility expanded, and terminology blurred. So this amendment seeks to prevent that. It would establish an independent safeguard and oversight body with clear and enforceable duties. Its responsibilities would include the need to review every case within 14 days after the substance was provided, maintain a national register of authorised medical professionals, investigate concerns about conduct or competence, audit compliance with law and regulations, and publish anonymised data on every assisted death, including demographic and clinical information. This body would be composed of legal, medical, ethical and patient advocacy experts, and crucially, none of its members could be involved in providing assisted suicide themselves. And everyone acting under this Act will be legally required to comply with the directions of this independent body. So this amendment is about vigilance. If the Parliament is determined to cross the moral line into assisted suicide, it must not do so blindly or complacency, and an oversight body is the minimum protection against the erosion of safeguards and the slow normalisation of assisted suicide that could happen under this bill. Amendment 203, Convener, proposes an adjustment to section 27 of the bill, and this provides that when there are review reports, that will specify how many medical reviews took place, what they discovered, and whether any cases were referred for potential prosecution. It adds real transparency and accountability to how the Act will be operating in practice. So thank you, Convener. I'm very pleased to move Amendment 199.
Thank you, Mr Fraser. Douglas Ross to move the Amendment 129 in Stephen Kerr's name.
Thank you very much, Convener, and I'm grateful for the opportunity to speak to Amendments 129, 201, 130, 204, 131, 132, 205, 206 and 218 in Stephen Kerr's name, which collectively seek to strengthen transparency, accountability and parliamentary oversight in the operation of this bill. These amendments focus on three interrelated objectives: ensuring that reporting is evidence-based and complete, that reviews are meaningful and inclusive, and that this Parliament retains a firm focus and control of such a grave and irreversible policy. Looking at Amendment 129, it expands the requirement for annual reporting to include aggregated data drawn from final statements under Section 16, specifically the average and range of time between the provision of an improved substance and death and the nature and frequency of any complications. These details are not mere statistics. They are the only way Parliament can judge whether this law, if enacted, truly achieves what it claims to achieve: a swift, humane and safe end of life for those who choose it. Amendments 201, 204, 205 and 206 clarify and tighten the framework for periodic reviews by requiring that each review be distinct, regular and informed by appropriate consultation. Amendment 206 in particular shortens the review cycle from 5 years to 2, recognising that the early years of operation will be crucial in detecting any problems or unintended consequences. These are not bureaucratic exercises, these are acts of vigilance. Amendments 130, 131 and 132 ensure that those most affected by the operation of the Act, hospices, palliative care providers, faith-based and charitable organisations and advocacy bodies, are consulted and protected. Amendment 130 explicitly requires reporting on whether any hospice or institution has experienced direct or indirect pressure to participate in assisted dying, whether financial, regulatory or reputational. It also asks whether the quality or availability of palliative care has been affected and whether further safeguards are needed to protect conscience, ethics and institutional independence. Finally, Amendment 218 introduces a sunset or continuation clause to ensure that this Parliament must return to review and reauthorise the Act after a defined period. A law that changes the relationship between medicine and mortality cannot simply be left to drift. It must be re-earned through evidence and accountability. Convener, these amendments in Stephen Kerr's names do not undermine the purpose of the bill, they dignify it. If Parliament chooses to legislate for assisted dying, it must also choose to face without evasion the full reality of what follows, the data, the consequences and the moral responsibilities that come with it. I therefore commend these amendments in Stephen Kerr's name to the committee as essential instruments of transparency, integrity and parliamentary control. Thank you.
Thank you, Mr Ross. Brian Whittle to speak to Amendment 202 and other amendments in the group.
Thank you, Convener. I mean, 202 is a really simple amendment. It's just that as part of the annual report, I'm asking that a review to ensure the independence of the registered medical practitioners is maintained in practice. Part of that would ensure that the data would be anonymised to adhere with GDPR, and also the review itself should be independent. I'll also speak briefly to Jackie Bailey and Pam Duncan-Glancy's amendments. It seems to me that it should be absolutely fundamental that the services and the system are able to cope and have the capacity required to deliver the bill, and that includes a review of palliative care and of social care as well. And I'm very struck with, once again, with Pam Duncan-Glancy talking about quality of life and how that moves. And I want to use a very simple example. You knew I would get sport into this somewhere. I'm very struck with the interaction with the power chair football, and there's a couple of reasons why I wanted to mention it. Firstly, the Ayrshire Tigers, it is so evident that that social interaction, that ability to be social, is really fundamental to their quality of life. Having seen a couple of them have an inability to participate because they were unable to get the transport to get to those, that very simple, which we take for granted, that very social interaction. And the other reason I wanted to mention that is because I never tire of mentioning the trauma that Alexander Stewart had when he played power chair football against the Scottish national team. He thought that sitting down motorised sport would be his way of getting involved in sport, and the trauma he has received since then has given me no end of joy. Convener.
I'm not quite sure how to respond to that, Mr Whittle, to be quite honest. I believe, Mr MacArthur, you wish to make a declaration.
Apologies, I should have done this at the outset of proceedings, listening to Miles Brigg declare his declaration of interest. Just to remind the committee that I am supported by Dignity in Dying, Friends at the End and Humanist Society Scotland.
Thank you, Mr MacArthur. That's now on the record. I propose to close this meeting for this evening. At our next meeting next week, we will continue our Stage 2 consideration of the Assisted Dying for Terminally Ill Adults Scotland Bill, and that concludes our meeting for today.